Next up, we have among us Arun Cyril Jose and Shima Madsudan. Arun Cyril Jose is working as an assistant professor in the Department of CSE at IIIT Kottayam. He have received the engineering degree in computer science from Mahatma Gandhi University, India in 2009. The master's is in forensic computing from Coventry University, UK in 2011 and PhD from Department of ECE from University of Pretoria, South Africa in 2017. His interests include information privacy and security, home automation security, security-based social engineering, network vulnerability, detection and intrusion prevention. And our next resource person, Shima Madhusudan, who is student member for IEEE, is currently working towards her PhD degree with computer science and engineering at IIIT Kottayam. Sir, the stage is yours and you can start your session.
Thank you. Yeah, and warm good afternoon, or rather a cold good afternoon to you all. Yeah, I'm sorry it got a bit delayed. Like we were supposed to start at 1:45. Sorry, it got a bit delayed. Okay, so today we'll see some fundamentals of cyber laws. Okay, so first we'll deal mostly with IT Act. Okay, so especially cyber laws in India, and we'll also see before we move on to the IT Act, I'd like to tell you the background that led to the IT Act. Okay, so initially around what do you call it? Around 1996, the United Nations, the UN, the UN Commission on International Trade and Law, UNICITRAL, they came up with a set of, what do you call it? A set of rules that just guided the way e-commerce is done. Okay, that is around 1996. E-commerce was becoming popular. There were e-contracts, there were e-banking, e-return, online trade. All those things were happening. So what the UN was trying to do is that they were trying to bring some sort of legitimacy to the deals that are being done. Okay, so they came up with the model law on e-commerce, which was adopted by the UN General Assembly around January 1997, to which India was a signatory to. So India was asked to make changes to its law in line with the proposed the UN proposed laws. Okay, that is the background of IT Act. Hence, around 2000, your IT Act came to be. Okay, so time went on. Around 2005, the UN Convention to use electronic communication in international contracts was adopted. That is basically, it gave some sort of legitimacy to your electronic contracts that were being done. Okay, so what that particular law did is, or what that particular thing did is that it facilitates the use of electronic communication in international trade. That is, it just basically gave validity to your electronic contracts, or it made it equivalent or as valid as a paper contract. Okay, so we have that. So later on, yes. So later on, next slide. Or you can give me the screen. You can give me the screen, so it will be easier for me to, like, that screen. I would like to change it. Yeah. No, the previous one. Oh yeah, this one. Okay. Yes. So again, around 2005, they have also identified certain or they have rather improved on the already proposed your cyber laws. Okay. Later, there was another convention for the South African development community. In that conference, various interesting questions were asked. Since they have what do you call it? Legitimized online contracts, the question was, well, in case of a lawsuit, where should it be filed? Since contract is between people from two or businesses from two different countries, where should the lawsuit be filed? Previously, we didn't have that question. Why? Because, well, all those things were guided by the same laws of the land, because contracts have been entered into by entities within the same jurisdiction or within the same country. Now the question is, since you have e-contracts becoming popular, now the question is, well, where should this particular lawsuit be filed? Whether it is, well, if two parties are being entered in, one party is in India and another party is in, say, Europe somewhere, which laws should apply? Okay, so these questions have been answered in section 13 under the IT Act, which have amended many times. Okay, so they did propose some valid questions, and then the question is, there were concerns regarding data privacy as well. That is, previously the question of privacy was, well, it was there. However, when your communication and techniques move to online, well, it becomes really easy to collect your personal data, and well, you could say that you are collecting data for one particular purpose. However, you could use it for another purpose also. Okay, then so as online communication became more popular, your issue of privacy also came up. Okay, now we will move on to some basic, some very basic things concerning crime. Okay, there are two things. Generally, for a crime to be prosecuted, you need two things. One is mens rea. It's a Latin word meaning guilty mind, and the other one is actus reus, meaning the act or the act of committing a crime. Okay, I'll explain. Your mens rea means your mental element that is required for criminal liability. Okay, so you can say that your mens rea could be like, there could be 4 different kinds of intent. One is your typical intent. That is, for example, if you are doing something and the consequences of your action are foreseen, and you decide that particular consequence, and you did that thing willingly, then, and that desired outcome is actually achieved. That is, your consequences are foreseen, and more importantly, you have desired that consequence also, and you have performed that action willingly, and your action resulted in the desired consequence. That is, for example, if I decided to beat somebody up, I went up to him, I beat him up, or I stabbed him. I have planned that action. I knew what I was doing, and I know what stabbing him will cause. Okay, so I knew the consequences of my action. I did it willingly, and the desired outcome is achieved. Okay, so that would be an example for criminal intent. Okay, so that is intent. Next is knowledge. Okay. In knowledge, you are aware of your actions, but you don't particularly care about the consequences. In intent, I knew what I was doing, I knew what it will do, and I did it willingly. In knowledge, I am aware of my actions and the and the consequences, but I don't really care whether that or care about the consequences. That is, for example, if I physically say how do you say it, lashes out at someone. Okay, I knew it is bad, but I don't really care about the consequence there. Most often, knowledge and intent, they do go hand in hand, or that is, you can't really distinguish between knowledge and intent. Okay, in most cases, knowledge and intent, they are more or less similar. Okay, next you have I don't, because my screen is not doing it. Display there. Okay, it's fine. It's fine. You keep it. Okay, so your next type of mens rea would be your recklessness. Okay, so that is so here you foresee the your prospective what do you call it, repercussions of your actions. Okay, but you don't intend to basically do that. That is, I know it is bad, but I didn't intend to cause it. For example, if I am drunk and driving, okay, and I hit someone, okay, while I am drunk and I started driving the car, I knew the consequences. However, I didn't intend to hit anyone. Still, such type of intent or mens rea comes under recklessness. Okay, that is, when I get behind the wheel of a car drunk, I knew that it is bad, or I could hit someone, even though I don't intend to hit that person. Okay, so that is an example for recklessness. Now, the least severe one would be negligence. Okay, here, I mean, in order to prove negligence, the prosecution has to show that he or she fails to meet a reasonable standard of behavior of her circumstances. That is, well, under these circumstances, whether a reasonable person would act this way. That is, for example, if I am a babysitter, or if you left your child under my care, and under that circumstances, due to my inefficiency, the child got hurt, that would be a negligence on my part. Okay. A better example would be in the state of Texas, if you saw that, or if you see a person has been in an accident, you are supposed to stop and help. Like, if you don't, you are negligent. Okay, so that is another example. So different states, or different, or it is the least severe of these things. Okay, so there you have to show that either, that is, you didn't act in a certain way that is expected from a reasonable person, or either you did act in a certain way that is expected of a what do you call it, reasonable person under that circumstances, or you did not act in a certain way as expected of a reasonable person under those circumstances. Okay, this is the least severe of these things. Okay, next would be actus reus. So it is the act of committing a a crime. That is, you need the intent, or you need these two things for most cases. Okay. There are exceptions which we will see if we have the time. Okay. Yes. Here, well, IT Act is actually pretty broad. Okay, it covers a lot of things. Section 1 covers where it is applicable, and under which circumstances it is not applicable. Section 2 defines a few basic terms in computer science. So we will deal with section 11, or I'll try to give one example from section 11 of the IT Act, which basically deals with crimes and their punishments. Okay. So yes. So tampering with computer source documents is covered under section 65. Okay. That is, what does tampering means? Well, any person knowingly or intentionally conceals, destroys, alters, or intentionally or causes another to conceal, destroy, or alter any computer source code used for a computer program, computer system, or a computer network, where the computer source code is required to be kept or maintained by law for the time being in force, shall be punishable with imprisonment up to 3 years, or a fine up to 2 lakhs, or with both. So here you can see a few terms. Okay. So I think it is pretty clear, even though for a technical person, it might look to be a bit of overkill, defining every little thing, but it is the law. So you have to be very precise and specific. Okay. So here, well, basically it says that if you destroy a computer source code, you will be punished with these two things. Okay. Now, section 65 again further defines what a computer source code is. Okay. Next. A computer source code means the listing of program computer commands. So basically, the law defines your computer source code as means a listing of programs, computer commands, design and layout, and program analysis of computer resource in any form. Okay, so that is the legal explanation for computer source code. Okay, so section 2 defines. So we have intermittently used the term computer as well. Section 2 clearly states what a computer is. Well, it might look to be a bit of an overkill, but yeah, it is. So the law defines computer as a means any electronic, magnetic, optical, or other high-speed data processing device or system which performs logical, arithmetic, and memory functions by manipulations of electronic, magnetic, or optical impulses, and includes all inputs, output. Yeah, you get it. Okay. So the point is that covers pretty much a whole lot, right? They know what they're talking about. That covers your calculator from, your high-end supercomputer, or your, what do you call it? You had your classes on advanced supercomputers, yes? No? Okay. So that covers from some cryptography class was there. What was the cryptography? Lattice cryptography for quantum computing. So that covers quantum that is from your calculator to your quantum computers. That definition of the law covers, or that definition of the word computer covers from quantum computers to your calculator to my cell phone, a lot of things. Okay. So the point I'm trying to make is that those guys know what they are talking about. Okay. So law is very precise because they have defined these things very precisely so that there is no ambiguity there. You can't get off on the technicality that, okay, I destroyed a phone. Well, by law, it is not a computer. You can't do that. Okay, so that is the point that I'm trying to make. And moreover, the word computer is used in a lot of laws in a very different ways. Okay, next. Well, Section 2 again further goes on to define what a communication device is, what a computer network is. These definition of a computer network, that is also very interesting. Means interconnection of one or more computers or computer systems or communication devices through uses of satellites, microwave, terrestrial line, wireless, or other communication media. Okay. So, and moreover, the connection doesn't have to be continuous also. Like even if it is intermediary or intermittent connections, still it forms a computer networks. So anyway, I will discuss one case and I'll move on to the, or I'll end my talk here. So there was a case. Next. There was a case which says Syed Asafuddin and others versus the state of Andhra Pradesh. It's an interesting case. Next slide. It's an interesting case. Well, I'll explain the case very briefly. Okay, the year is 2005. You have petrol was 40 rupees, 45 rupees. No, and MS Dhoni was he made his debut in 2004. So in 2005, he was playing against Pakistan, scoring 200s. No, yeah. Okay, so the year is 2005, and Reliance has got, they have under their Dhirubhai Ambani Pioneer scheme, they are coming up with a cell phone that is worth 10,500 rupees. They are giving it away for 3,500 rupees. But the catch is you will have to stick with that company and you will have to pay like 600 rupees per month to continue with the plan. Okay, so that is, you are getting a phone that is worth 10,500 rupees for 3,500 rupees, but you have to stick with their plan for 3 years and you will have to pay 600 rupees each month. Okay, so it was a very popular plan at the time. Okay, and what happened was, and the phone was manufactured by LG and Samsung, and they had exclusive rights to or rights with Reliance. Okay, so what happened there was some sales people from Tata Docomo reached out to these customers saying that why should you stay with this 600 rupee monthly plan when you can switch to the cheaper Tata Docomo with the same phone, but it was illegal. Okay, so what they actually did was, there is something called just give me one moment. Okay, there is something called electronic serial number. So what those Tata Docomo guys were promising was, you could still use the same phone. You don't have to pay them the 600 rupees. At the same time, you can switch to a cheaper Tata Docomo thing without, or you will be able to save money. So what they did was, each phone has got something called electronic serial number, ESN for short. That was the forefather of what do you call it? Now you have your IMEI number, right? So that was the your ESN was your 32-bit identification for phones at the time. Okay, so what those Tata Docomo guys did was, they have manipulated this ESN number as well as an SID, system identification code, which is used to, so your ESN number is used to identify the phone, your ESI or your SID, your system identification code, it is used to identify the service provider. Since the phone is locked with Reliance service provider, your SID would manipulating that would let you change the service provider as well. Okay, so they did this. It went to court. A case was filed against Tata Docomo employees. So they were charged with various sections of IPC, IT Act, and Copyright Act. Okay, in one of the judgments, the judge said that cell phone is a computer as mentioned under the IT Act, which we have seen what a computer is. And the judge goes on to say that ESN number and SID come within the definition of computer source code as per the definitions that we have seen. Okay, so altering the ESN number and SID, yes, so you are eligible to be prosecuted under section 65, which we have just seen. Okay, so that is one case. There are, so this is how you should be. Can you go to the, you can move on a few slides. Okay, so move on. So I've also back. Yeah. So I've also included next slide. Yeah. So there are a lot of sections under the section 13 that we were saying. So section 66A deals with certain things. 66B, C, D, E, F deals with all these things. Okay. So I've just given you an overview of how to look at one offense and how to understand and study it. Okay. So I'll yield my time to Ms. Shima, who will be explaining international perspectives on cyber laws. Thank you.
Good afternoon, all. So as said, I'm Shima. I'm a research scholar under Dr. Arun Cyril Jose. So today, I would like to give you an overview on international perspective on privacy laws or cyber laws. So this is the overview. We'll try to cover European Union privacy law, USA law, and few case studies. Okay. So as you all know, we all are into online social network. Am I audible? Okay. So we are all into online social network, right? So it's getting proliferated day by day to a huge amount or a massive amount. So what happens is protection of these data become a critical condition. As in, if you see, when you give your information through social networks like Facebook or Instagram or whatever, you're giving your profile photo, you're giving your profile information, even you're giving your profile information of your parents, friends, and everybody possible. So the challenge is that these information can get misused. Okay. So ensuring privacy to all these data that you give to online social network is a critical thing. For that, European Union has come up with General Data Protection Regulation in the year of 2018. Okay. So it is under the European Union, which covers Iceland, Norway, UK, etc. So what happens over there is they try to protect personally identifiable information, including, suppose say if you're we all are an individual, so we'll be having different political opinions, we'll be having different religious or philosophical beliefs, union memberships, etc. So all these needs to be protected, and for that they have come up with this particular law, that is General Data Protection Regulation. Okay. So for protecting the fundamental rights and freedom of the data subject, they have considered these eight units, or you can say 8 different partitions. The first one is data subject, or whose personal data needs to be protected. That particular individual is called as data subject. The next one is personal data, as in what information you want to, get it privatized. So that is personal data. The next comes data processor. Data processor is an entity who actually process your data. The next one is the process of data processing. The next process in GDPR is profiling, wherein they record and analyze the data correlation within the personal data you're submitting to the through the online media. The next is data controller. Then they governs with personal data breach. And then you have a DPO. DPO is the person who will administer all over the processing of personal data. So this is applicable to all European Union member states in all sectors for all the purposes, whether it be commercial or non-commercial. Okay, so in GDPR, they say that individuals have these many set of rights. The first one is right to be informed, which means that if you are collecting a data, if any organization is collecting a data, the individual has right to be informed on what data is being collected. He also has the right to access to that data. Also, the individual will have a right to rectify the data. If the submitted data is wrong, if the individual feels that, oh, my data is wrong, what is being submitted over there, he has the right to rectify it. He also has the right to object it. But these all cases differ. Like if they are into some, criminal cases or something, then these cannot be considered, but still. The next one is right to erasure, right to data portability, right to restriction of processing. So these are the basic rights being given to the individuals whose data is subjected to protection. Okay, so these are the primary stages in GDPR. The first one is data collection. The next is GDPR profiling, then data storage. So what happens is during the data collection, the data is collected through primary sources and through secondary sources. Secondary sources in the sense I can get your data through your friends too. So that is known as secondary data collection. Then after which the GDPR does a profiling, understands the correlation among the data, identify the patterns and predict on what your interests are, what your ethnicity is, what are your political views, etc. Then next is data storage. They store the data for a particular time period, say 6 months or 6 to 1 year, 6 months to 1 year. Then they give the right to an individual to withdraw his or her data if found, if it is found critical, then a data subject can withdraw their data. So these data which is being stored is anonymized and kept in the storage. Do you know what is anonymization? To keep identities unknown. Yeah, you might have seen, right? This mail is sent to s*** at gmail.com. That star comes in between, that is anonymization. Okay, so data anonymization, territorial scope, as in GDPR EU, if a data is being transmitted between the countries in European Union, then that is accepted. But those data cannot go out of EU scope where this GDPR is not applied. So that is what is territorial scope. Okay. Okay. This is a case study to make you understand what a right to rectification is. I said before that an individual who is, giving their data to be protected, he has the right to rectify it, which means suppose say there is an employer and an employee. Employer needs to make a psychometric test on the employee. So he will consult a psychologist, right? To get to know whether the employee is fit for an employment, or maybe he took a leave or long leave. So to get to know whether he's okay or apt for a job. So what happens is once the employer asks psychologist to evaluate on employee, psychologist will prepare a note and then provide it to the employer. As per GDPR, employee will have all the rights to get the data. So such a situation happened in USA, I think in 2020. So what happened is the employee found that his data was not correct, or the data presented by the psychologist was not right. So what he did, he filed a case against the psychologist. Then they formed a consortium and everything, and then they found that they can annotate that data. Annotate means they'll strike out what is not relevant to that data subject. They annotated it with an explanation. So this is how GDPR is being carried out. Clear? Clear? Okay. So now, okay. This is another experiment conducted by few researchers to get to know how GDPR is functioning. So what they did is they wanted to conduct an experiment over data collection. They tried to inform all Twitter users that we are going to conduct a GDPR survey. So want to know how effective it is. So they started collecting the data and collecting the data by informing the Twitter recipients that your data is being collected. But what happened is Twitter blocked them and they could only send around 2,400 messages or so telling that your data is being collected because there was a limit that Twitter had kept. So finally, they had to drop this experiment. And also GDPR obligations made Twitter to leave a message like that. So what happened is they had to stop the research. So what the observation what we can make is GDPR is too stringent to be followed, or it is too tough. They are practically impossible to achieve because so much of restrictions are being given to many places. Fine. So let me move on with the laws in USA. As everybody knows, if you take a graph, there is a very much increase or peak in the people using online social media. So today, 85% of the American adults are said to use online on every day, maybe per second. So the threats, as you know, are exploitation of personal data, manipulation of consumer behavior, and the rest goes on. So coming to the laws, you might be familiar with few. Okay. Have you heard of HIPAA and COPPA? I'm sure you might have heard of this. HIPAA. No. Okay, HIPAA is related with health information protection. Next is COPPA, with this child protection. Then video privacy protection, ECPA, FCRA, GLBA. Okay, I'll go one by one. HIPAA is related with health information. Again, it will be coming in the next slides. Next is COPPA, that is for children protection. Then you have VPPA, that is Video Protection Act, to protect the videos under storage. The next one is ECPA, that is for Electronic Communication Protection Act, wherein wired communication, phone communication, etc. needs to be protected. So this law came for that purpose. And then is FCRA and GLBA that governs with credit cards, finance related stuffs. Okay, to protect the finance transaction details, we have FCRA and GLBA in place. Okay, so these are the four comprehensive consumer data privacy laws. Okay, California, Colorado, Virginia, and Utah, they all rely, or they all are made to protect consumers' personal information while in a business or while sharing commodities or while purchasing something. So there are places where we have to give our information while you are purchasing a good, right? So for all that, they have come up with these four acts. So yeah, that's about Consumer Protection Acts. Now coming to HIPAA. HIPAA is Health Insurance Portability and Accountability Act. Do you think that your health information needs to be protected? Yes, right? So HIPAA is kind of a protection act that came into existence in 1996. So the covered entities are healthcare providers, then health plans, business associates dealing with health information, or medical representatives, such kind of entities. So what it says is an individual has always right to control the data that is being given to another person, because I'll have the right on my data or my illness of where it should be given to. And it goes on with the principle of CIA triad. I'm sure after having heard of workshop of 5 days, you will be knowing what is CIA triad, right? So confidentiality, integrity, and availability. So the security rule of HIPAA is that they need to ensure the CIA. Okay, now that is the crux of HIPAA. Now, this is a recent case history. There was, you also might have seen, right, in YouTube or social media or web browsers, you can see people who had done plastic surgery before and, sorry, a person's original photo and photo after plastic surgery. You might have seen, right? So similarly, a plastic surgeon stored a patient's photograph before and after surgery for his profile making or whatever. And he posted it in public platform. Sorry. Okay. So he posted it in public platform. And then what happened is the patient found his photo over his profile, over his doctor's profile. So then the plastic surgeon argued that your name is not there, your demographic details are not there, your place is not there, your gender is not there. So what is wrong in me keeping your photo? But then according to HIPAA did not protect images. Okay, HIPAA was just telling that the data should be protected. They did not say that the images needs to be protected. But later on, what happened is in the image, there was a metadata which said every details of the patient. So the patient could get de-identified and the case was filed against the plastic surgeon. So this is a recent case study that happened last year. Now coming to next act, that is Graham-Leach-Bliley Act, which I said before, GLB Act, to control the finance transactions, wherein it preserves NPI, that is personally identifiable, non-public personally identifiable financial information. Okay, so this is applied to financial institution, customers and consumers, and businesses that receive this NPI. There are, though this rule is stringent, we can also opt out from this rule. If a person is willing to opt out from such a kind of a privacy rule, he can. Now, next is COPPA, that is Children Online Privacy Protection Rule. Do you think that this is necessary? Why? He might. Yeah. Children may get inappropriate content. That is one thing. The other side, can you just think of? True. So what happens is children under 13, if they are given the privilege to use the online social medias without the consent of the parent, there can be people who are requesting for their photos, who are passively tracking the children, which is a harm for them. So COPPA Act is an act wherein they say that for any communication which is made by a child aged less than 13 should have his or her parents' consent to do that. The recent case was with Xanga company, which asked children to post their photographs, and they were keeping it as a repository, and they were charged or fined for $1 million. Okay, so that's again the recent case that had happened. Now coming to general privacy regulations, one of the acts that happened in 2021, that is Social Media Privacy Protection and Consumer Right Act, S.1667, which covers protection over online platform and geolocation, which means you might be using maps, right? Google Maps, or you might be using social network, so social login checks. When you go to a hotel, you might log in, or when you're using a metro, you will be logging in international countries. So these kind of locations get stored and people can breach the data. So for protecting that, Social Media Privacy Protection and Consumer Act has come to existence in 2021. So according to that act, the individual can give a specification on their privacy preference, whether they like to be known as anonymous or whether they like to be known as their own name. Such kind of privacy preferences are given according to this particular act. Next is social media privacy laws in the workplace. which is very common. Even I think in India also now few of the companies are following that, wherein it states that we shouldn't be using our social media accounts with our office email ID, nor we should ask our friends to be our friends in Facebook. So, or Instagram. So the same thing is about social media privacy laws in workplace. Now, again, coming to next case, that is, okay, the next one is, we all have used Zoom. Zoom says that it is end-to-end encrypted, 256-bit encryption is their secure connection. Your video will not be given to anybody and all that. But in reality, Zoom maintained a cryptographic key, which could retrieve all the videos. Videos means it's with the face and everything, right? So maintain the cryptographic keys that could allow Zoom to access the content of the customers' meetings. So this was again a case filed, and what they did was they had kept the recordings for 60 days or something. So in that 60 days, they can manipulate, right? So yeah, so there was a case filed against that, and now they are mitigating it by deploying safeguards, by not keeping the records for more than a prescribed time, by encrypting the storage media and etc. So by seeing the laws of both European Union and USA, what do you find? Do you find any difference, or which do you feel is flexible? Which do you feel is apt? We found that in EU, GDPR covered everything, but in US, it is divided into multiple laws, right? Multiple state level laws. So yeah, that is the difference. In America, it is little more flexible, but the thing is, they don't have one particular law to govern everything. So international privacy laws for data protection will continue to evolve and develop to ensure personal data protection. USA, as I said, still lacks comprehensive privacy measures. There is no US equivalent EU GDPR. Okay. Then the problem with EU GDPR is that it imposes high level of restrictions, and they have stringent regulations. Now, India is trying to find a right balance between both. Get the advantages of both European Union and America, and we'll have to wait and see of what law they will put forward. That's all from me. Thank you all. I hope I did not make you feel bored. Yeah. Thank you. Thank you all.